was sent to the relevant staff of the defendant. By an email dated 11 September 2015, the claimant was warned of an alleged manipulation of fuel receipts and invoices of the claimant's purchases on 13th day of May 2015 and 14th day of May 2015. However, by another email dated 15 September 2015, the warning email was withdrawn for the purpose of additional inquiry. By an email dated 16 September 2015, the claimant was made to appear before a disciplinary panel. Sequel to the panel's report, the claimant was dismissed with immediate effect by a letter dated 26 November 2015. The claimant contests that the dismissal was unfair, unconscionable, malafide, and inconsistent with the policies and procedures of the defendants. In the defendant's statement of defense dated and filed on the 14th of November 2016, the defendant denied each and every allegation of facts in claimant's statement of facts. The defendant stated that the invoices generated by the claimant were made with malicious intent to defraud the defendant, and the claimant used his position to compel the defendant's staff to produce a manipulated fuel receipt. That at the time the earlier letter of warning was sent to the claimant, the defendant was not well abreast of the fraudulent acts. That during his appearance at the panel, when he was asked why he increased the fuel receipts by 4,000 naira only, he said he did so to cover for the food he bought on the way. That the claimant was dismissed because the disciplinary panel was convinced that the claimant was dishonest and abused the defendant's policy by falsifying receipts and overstating the amount of fuel purchased by 4,000. That as at the time the claimant was dismissed, he was indebted to the claimant to the tune of 345,976 naira 25 kobo, which the claimant has refused to liquidate despite a demand made on him. Now, trial in this matter commenced before the court on the 8th day of November 2022, to which the claimant was called as a witness to testify in chief. During his examination in chief, he tendered documents that were admitted as exhibits. Subsequently, he was cross-examined by the defendants. There was no re-examination, and claimant closed his case on the 8th day of November 2022. On the part of the defendant, it opened our defense on the 19th day of March 2025 by calling one Mr. Olasukomi Babalola, who identified himself as a banker working with the And do you have those numbers of it?
Is this a Zoom that is going off?
Has it? What is it? I mean this. The second issue for determination is whether the claimant has adduced sufficient evidence to be entitled to the relief sought in his claims. And the third one is whether the defendant's counterclaimant has established any loan debt against the claimant and entitled to its counterclaim. Now, gentlemen, because of the length of these addresses, I've just mentioned the issues to be determined, but I'm going to skip the actual address by each of the councils because it is each one of them is quite lengthy. So I'll go to the defendant. On receipt of the defendant's final written address, the claimant responded through a final written address dated 20th July 2025, but filed on 22nd July 2025, formulating two issues for determination. And these two issues are: one, whether, based on evidence before this court, the claimant is entitled to the relief sought before this court. Two, whether the defendant is entitled to the payment of the sum of 327,810 naira 29 kobo. On issue number one, the learned counsel to the defendant made copious submissions, which I will also skip because their submissions are quite lengthy. And on the second issue, learned counsel to the defendant also went to town on his submission. So at long last, having gone through the case for the claimant, that of the defendant, the evidence adduced on both sides, and the final written address of the parties before the court, this court has distilled two issues for determination, to wit: one, whether, given the circumstances, the claimant has proved his case to be entitled to the relief sought. Two, whether, given the circumstances, the claimant has proved his case to be entitled to the relief sought. The case of the claimant is based on wrongful dismissal. From the particulars of wrongful dismissal and bad faith listed in the body of the amended statement of facts, the claimant stated same to be: A, that the defendant, in a letter of warning dated 11 September 2015, cautioned the claimant to avoid unethical conduct and will not hesitate to apply stiffer sanction on reoccurrence. B, the rash withdrawal of the letter of warning and constituting inquiry without any reoccurrence forthwith is mal affide and unconscionable. C, The issuance of letter of suspension in less than 24 hours after withdrawal of letter of warning is a clear case of employer's malafide to the employee. D, the subsequent constitution of a disciplinary panel, that is for further investigation, without any further recurrence. Where the claimant appeared once and his unconscionable dismissal was orchestrated to deny the claimant his proper terminal entitlements after meritorious years of service to the defendant. E, that the basis for the purported dismissal is not within the purview of the parameters of the defendant's human management policies and procedures. In the case of Nimasa versus Esowe, reported in 2014, citation fully supplied, the court held, and I quote, a claimant who seeks a declaration that his employment has been wrongfully terminated must prove the following material facts, namely, A, that is an employee of the defendant, B, that the terms and conditions of his employment, okay, he must prove the terms and conditions of his employment, and C, the way and manner and by whom he can be removed. It is not in principle for the employer who is a defendant to an action brought by the employee to prove any of this. From the above, it is clear that the duty of proving wrongful termination rests on the claimant and not on the defendant. In issue 1 of the claimant, learned counsel to the claimant submitted that the defendant's unsigned and nameless disciplinary panel report with a supposed date of hearing but no execution date is a worthless document and inadmissible in evidence, and even if admitted, has no evidential value. First of all, I want to say that it is not in dispute that the claimant faced a disciplinary panel. He alluded to this in his statement of facts, and the defendant also alluded to this in his statement of defense. Therefore, the general principle of law that facts admitted need no further proof applies in this case, and I so hold. Today, now, please open the. Please open the window. Thank you. Jesus Christ. Honestly.
Okay, sorry.
Okay.
I can hear you.
So, okay. So from the above, it is clear that the duty of proving wrongful termination rests on the claimant and not the defendants. In issue 1 of the claimants, learned counsel to the claimant submitted that the defendant's unsigned and nameless disciplinary panel report is a supposed date of hearing, but with a supposed date of hearing, but no execution date, is a worthless document and inadmissible in evidence, and even if admitted, has no evidential value. First of all, I want to say that it is not in dispute that the claimant faced a disciplinary panel. He alluded to this in his statement, and the defendant also alluded to this in his statement of defense. Therefore, the general principle of law that facts admitted need no further proof applies in this case, and I so hold. See the case of Dr. Ara Eresia Eke and 2 others versus Elder Jackson Orikoha, and 2 others, reported in 2010. 8 Nigeria Weekly Law Report, part 1196, page 421 at 430. Secondly, the claimant's claim is not based on the composition of the disciplinary panel. There is no complaint of such in the body of the claimant's statement of facts. No complaints, disputes, or issue joined on the date of hearing of the disciplinary panel on the pleadings before me. It is therefore immaterial for the claimant to raise all these issues in the body of his final written address. It suffices to say that a written address, no matter how beautifully couched, cannot take the place of pleadings or evidence. See the case of Okuleye versus Adesanya, quoted in 2014, 12 Nigeria Weekly Law Report, part 1422, page 521 at 539, paragraphs B to C. Flowing from the foregoing, the arguments of learned counsel to the claimant on the document tendered as Exhibit D2 by the defendant goes to no issue, except the point made on an unsigned document. Furthermore, being that the convergence of a disciplinary panel is a fact that both parties have admitted, also holds. On the issue of the warning letter and its withdrawal, the court wishes to state that whenever a law or rule donates a power to anybody, it also donates the ancillary discretion to the person in carrying out the dictates of that power in matters that are not specifically mentioned. In the case herein, the power to issue warning, inquire into allegations, suspend and or dismiss have been donated to the defendant. The claimant cannot dictate for the claimant on how to apply his discretion in the exercise of this power. In this vein, if the defendant issues a warning letter, but on a second thought decides to withdraw it, that was solely at the discretion, at his discretion to do so. Where he decided to suspend the claimant to pave way for inquiry, it is also within its power and discretion to do so. If he decides to set up a disciplinary panel to which the claimant was invited to clear its name, it is also a procedural requirement that it is expected to carry out. Therefore, the position of the claimant on those that amount to wrongful dismissal cannot be fully appreciated by this court. Generally, cases are won on the pleadings and evidence laid in support of the pleadings, based on the fact that the will starts from how the pleading is couched. A badly couched pleading may be fatal to the case of the claimant. When a claimant brings a case before the court, complaining of a wrong done to him, it is his duty to lead evidence to support his case. The defendant may decide to just fold his hands and just watch. This does not in any way prevent the claimant from leading evidence in proof of the averments made in his pleadings. See the case of Alhaji Tajuddin Ibrahim Olagunju versus Alhaja Habibat Yahaya, quoted in 2004, 11 Nigerian Weekly Law Report, at 883, page 24. The Court of Appeal had this to say, and I quote, "In a civil suit, the person who asserts has the primary burden of proving his assertion. The failure of the defendant to prove or his refusal to testify cannot alleviate the primary burden on the plaintiff." The claimant, who has been so logical in his assertion of wrongful dismissal, still owes the court the duty to point the court to any rule violated by the defendant in his dismissal. Failure to point the court to any laid-down procedure or rule that was not complied with by the defendant is fatal to his case. See this case of State versus Aibangbe, reported in 1988, 3 Nigeria Weekly Law Reports, Part 84, page 548 at 577, where the Supreme Court, per Esowe, JSC, held as follows, and I quote, "A judge of first instance decides on the evidence led by the parties to a case before him. He does not, with respect, concoct evidence. He does not imagine evidence. He interprets a situation as per cold facts before him, not as per what he would have preferred the facts to be." In proof of his case, the claimant did mention that his dismissal did not have any justification under the Human Capital Manual, and also repugnant to the Human Capital Manual, and therefore wrongful in its entirety. He did not tender Exhibit C8, which is the Human Capital Management Discipline. In Chapter 4 of the Human Capital Management Discipline, it is headed Credit Infraction. At page 5, under the subheading of offenses, paragraph 3 is titled Misrepresentation of Information or Fraudulent Reporting resulting in financial loss. No financial loss. The immediate action for this, as provided, is indefinite suspension pending determination of defense counsel's decision. Definite suspension without pay. Under the column Further Action, it is stated that disciplinary committee to recommend range of actions specified. Then under the column Range of sanctions, the range is stated as warning, termination. Now, the general rule of thumb is that what is good for the goose is good for the gander. Applying this to the claimant, it means that the maximum punishment for the infraction he committed in inflating or misrepresenting the amount he used for fuel can only, at worst, attract the punishment of termination and not dismissal. The defendant who used the bigger hammer of dismissal on the claimant has not been able to point the court to the portion of his own rules or the Human Capital Manual that provides for dismissal for the infraction committed by the claimant. From all that have been said, the court finds and holds that the dismissal of the claimant was wrong. Consequently, it is hereby converted to termination, and the claimant is entitled to all his terminal benefits. I notice that the claimant in relief number 5 of his claim asked for 8 million naira as terminal benefits. However, he did not tell or prove to the court how he arrived at this sum. This head of claim falls under special damages, and as such, it must not only be pleaded but strictly proved. See the case of Akinkube versus EH Nigeria Limited, reported in 2008, 12 Nigeria Weekly Law Reports, Part 1098, page 375. Not proving how he arrived at the amount claimed as terminal benefits leaves the court with no option other than being a speculator. By that, as it may, be it as it may, the settled law is that a court cannot speculate on facts and evidence not before it. Therefore, in the absence of facts and evidence in support of claimant's benefits, this court can only hold that the defendant shall calculate the benefits of the claimant in strict compliance with its rules and terminal benefits and same should be confirmed by the claimant and or his legal counsel, and payment should be made to the claimant immediately. That the calculation shall include salary in lieu of notice. As for relief number 3 and 6, which are on refund of sum debited by the defendant from the claimant's Diamond Bank account, the court is not moved to grant the same, arising from its vagueness. Vague because it didn't mention any specific amount, nor the purpose the money was debited. Furthermore, it did not flow from the pleadings of the claimant. Relief sought should flow from the pleadings. Where no proper foundation was laid in the body of the pleadings, any relief that is extraneous and alien to what is pleaded is of no relevance. In this vein, relief number 3 and 6 are bound to fail, and I so hold. As for relief number 7, which is on cost of litigation, the court wishes to state that given the circumstances of this suit, it is not moved to grant any sum as cost. Now, moving on to issue number 2, which is whether the defendant has proved his case to be entitled to the sources of his counterclaim. The basis for the counterclaim is that the defendant is indebted to the claimant to the tune of 327,810 naira 29 kobo as an amount due to personal loans granted by the claimant. Interestingly, the defendant did not tender any document in proof of their case as regards the request for the loan and the grant of same. The defendant only made reference to a demand letter without more. In any event, the track law is that failure to lead evidence in support of averments made in pleadings is tantamount to abandonment of such pleadings. In this vein, the court cannot help but hold that the defendant is deemed to have abandoned his counterclaim. Consequently, the counterclaim of the claimant fails, and same is hereby dismissed. From all that has been said above, the relief sought by the claimant succeeds as follows. Relief number 1 succeeds. Relief number 2 succeeds. Relief number 3 fails. Relief number 4 fails. Relief number 5 succeeds only to the extent that the defendant shall calculate the claimant's terminal benefits and pay same to him immediately. Relief number 6 fails. Relief number 7 fails. The court shall make no orders to costs. Parties shall bear their respective costs, and this is the judgment of the court, and it is entered accordingly. Yes. So, call up the next one.
Case number NICN/L/A/306/2019 between Mr. Sanjo Oyelara and AC Nelson Nigeria Limited. What is our sentence, my lord?
Okay. Appearances, please.
Respectfully, my lord.
Yes.
Ayorinde Akimbowo. Appear for the claimant.
Okay.
My name is Grace Niegwe. My humble appearance is for the defendant in this matter.
Okay. So, Ms. Ayorinde, Kindly repeat your names to me so that I won't make any mistakes. Ayorinde
Akimboyo.
Akimboyo.
And my Lord Grace Migwe.
Yes, it's recorded.
Let's copy this.
Okay. So, excuse me. Three oh six. So this is the judgment. This suit was instituted by the claimant by the complaint dated and filed on the first day of July 2019, asking for the following reliefs. A declaration that the dismissal of the claimant by the defendant is wrongful and unlawful. B, the sum of 2,463,756 naira, representing claimant's 1 year gross salary as damages for wrongful dismissal of the claimant. C is the cost of this suit. The summary of the claimant's statement of fact is that he was an employee of the defendant starting from 19th November 2001, when he was employed as a field auditor operating from Yola, Adamawa State. At the expiration of his 6 months probation period, his employment was confirmed on the 6th day of May 2003. He was later elevated to the position of a supervisor via the letter dated 23 June 2005. He remained in the employment of the defendant until 2018, when his appointment was unlawfully terminated. Prior to the termination of his employment, he was transferred to Kano as a supervisor in 2018. However, in a query dated 2nd July 2018, the claimant was queried on allegations of fraud and negligence, to which he responded promptly. On the 30th of July 2018, the claimant was suspended for 1 week, following an invitation to face disciplinary panel in Lagos on the 2nd day of August 2018. Furthermore, in a letter dated 2nd August 2018, the claimant was dismissed from the employment of the defendant. The claimant is of the view that the letter of dismissal dated 2nd August 2018, but commencing retroactively from the 13th July 2018 is wrongful, unlawful, and constitutes a violation of the claimant's terms of employment. It also shows that before the query dated 27 July was issued, that the defendant had already made up his mind to dismiss the claimant. The claimant has therefore instituted this suit to challenge the unlawful dismissal. In the defendant's statement of defense dated 25th of October 2019, but filed on 28th of October of the same year, the defendant denied such an heavy allegation of facts in claimant's statement of facts. The defendant stated that the job description of the claimant as a field supervisor are clearly spelled out in a document signed by him, and they include overseeing the quality of work done by auditors and keep track of their designated area retail shops. That the defendant's employee handbook stipulates that an employee who has been found guilty of gross misconduct may be summarily dismissed where he has not been able to exculpate himself after being given the opportunity to do so. That in the case of the wrongful dismissal complained of by the claimant, the defendant investigated the activities of his auditors in Yola and Kano, where he discovered that data being sent by the claimant was different from the data reports received. Certain infractions were being committed by auditors which the claimant was not reporting. Therefore, he was not adhering strictly to the defendant's RMS field control standard procedure. This RMS procedure requires the claimant to screen and ascertain the reliability and veracity of reports provided by auditors working under his supervision. Two of such auditors, Andrew Michael and Emmanuel Anyoga, were indicted in the course of the investigation and they were dismissed. The testimonies of these two also implicated the claimant. Consequently, the defendant issued a query to the claimant on the 27th of July 2018, to which the claimant responded to via an email dated 28th of July 2018. That in the claimant's reply to the query, he admitted that there were mistakes and typographic errors in the data collected and submitted by the auditors in Yola and Kano. That most dates of purchases collected were in oral form due to the shop owner's inability to maintain diaries. That Andrew Michael cheated in outlet number 022266, Kano. That the claimant's submissions of work plan that didn't have visit time was an oversight on the claimant's part. Outlet classifications was done on auditor's phone, which the claimant did not have access. The claimant appeared before the disciplinary panel and gave oral evidence, and having failed to exonerate himself, he was dismissed from the employment of the defendant via the letter dated 2nd August 2018. The defendant stated that amongst the reasons the claimant was dismissed is because he was negligent in the performance of his duties. On the impropriety of the dismissal letter dated 2nd August 2018, having a retroactive instruction on the letter that the dismissal takes effect from 13 July 2018. The defendant stated that the 13 July 2018 timeline was an error and that the dismissal was to take effect immediately, which by immediately, it is the 2nd day of August 2018, on which the letter is dated. It is the position of the defense that this case is frivolous, vexatious, and lacking in merit. Therefore, this court should dismiss them with substantive cause. It must be stated that on receipt of the defendant's statement of defense, the claimant filed a reply dated 23rd February 2020, but filed on the 25th day of February 2020. Trial in this matter commenced before me on the 7th day of December 2021, to which the claimant was called as a witness to testify in chief. During his examination in chief, he tendered documents that were admitted as exhibits. Subsequently, was cross-examined by the defendants. There was no re-examination. The claimant closed his case on the 15th day of February 2022. On the part of the defendants, they opened their defense on the 18th of July 2024 by calling one Eric Adodo, who identified himself as the operation land lead of the defendants. He adopted his witness statement on oath, gave oral evidence, tendered documents that were admitted in evidence, and he was cross-examined by the counsel to the claimant. There was no re-examination, and therefore, thereafter, the defendant closed their case, their defense. The case was then adjourned to enable the parties file, exchange, and adopt their final written addresses. So, in this case, the final written addresses of both counsel to the parties was a little bit lengthy. So the court is going to skip it. I will not read them out, but I will read out the issues for determination and then go on with the judgment. So in the defendant's final written address, dated 25th November 2024, but filed on 28th November 2024, the learned counsel to the defendant formulated 2 issues for determination. That is 1, whether the dismissal of the claimant was valid. 2, whether the claimant is entitled to the monetary reliefs claimed. Those are the 2 issues. I'm going to skip the submissions, the lengthy submissions. Then on receipt of the defendant's final written address, the claimant responded through a final written address dated 12th February 2025, but filed on the 13th February 2025, formulating 2 issues for determination. And these 2 issues are: 1, whether, considering the facts and evidence before this honorable court, the claimant was not wrongfully and unlawfully dismissed. 2, whether, based on the evidence and facts adduced, the claimant is not entitled to the relief sought in his statement of claim. Then the court is skipping the written address itself. Then on receipt of the claimant's final written address, the defendant filed a reply on points of law, dated 22nd July 2025, and filed on the same day, to which the learned counsel replied on points of law and adumbrated further on such points. So, having gone through the case of the claimant and that of the defendant, the evidence adduced on both sides, and the final written addresses of parties before the court, this court, while adopting the issues formulated by counsel representing the claimant and the counsel representing the defendant, has distilled a sole issue for determination. That is to say, whether, given the circumstances, the claimant has proved his case to be entitled to the relief sought. Basically, the case of the claimant is that he was wrongfully and unlawfully dismissed from the employment of the defendant. From the body of the claimant's statement of facts and his reply to the defendant's statement of defense, the ground relied upon for his alleged wrongful and unlawful dismissal is that the dismissal violates the terms of his contract with the defendant. It is wrongful for being retroactive, meaning that the letter is dated 3rd August 2018, but stated that his dismissal takes effect from July 2018. Okay. That this dismissal was premeditated and he was made to suffer for the sins of others. Huh? Okay. Hoping that everybody is hearing me. On the part of the defendant, it maintained that the dismissal was not wrong or unlawful, as the defendant investigated the activities of his auditors in Yola and Kano, where he discovered that data being sent by the claimant was different from the data reports received. Certain infractions were being committed by the auditors, which the claimant was not reporting. Therefore, he was not adhering strictly to the defendant's RMS field control standard. Is related by both parties. Issue number 1 of the defendant and issue in different words. The defendant's argument is that the dismissal of the claimant was valid. On the part of the claimant, his position is that his dismissal was not valid but wrongful and unlawful. One of the most contentious issues in the final written addresses is the letter of dismissal, which is dated 2nd August 2018, but stated in his body that his dismissal will take effect from 13th July 2018. To the claimant, this makes the dismissal invalid. To the defendant, this is just a typographic error, and it is settled law that dismissal cannot take retroactive effect. They both relied on judicial authorities. As rightly posited by the defendants, dismissal cannot take retroactive effect Rather, it takes effect immediately the employee receives a letter of dismissal. In the case of Akimbola versus Ministry of Federal Capital Territory and another, reported in 2018, LPELR 45848, Court of Appeal. The Court of Appeal held that the dismissal of an employee takes effect from the day his dismissal letter was written and served on him. Where there is a retrospective dismissal letter, a dismissed employee is entitled to keep his salary due to him up to the date of his dismissal letter. The validity of a retroactive dismissal is limited to the matter of the date. In this vein, a retroactive dismissal may be invalid in form. It is not invalid in substance. Therefore, whether invalid in form, it does not defeat the substance that the employee has been dismissed. The only remedy in the defect is in form is that the employee will be entitled to salary from the date of the retroactive period till the date the letter was written and served on him. In this vein, the dismissal of the claimant cannot be invalid on the ground that it was made to have a retroactive date. Another heated point by the parties is the compliance and non-compliance with the terms of contracts between the parties in the way and manner the employment of the claimant was brought to an end. The defendant argued that defendant's policies make provisions for termination of employment, including summary dismissal. That Exhibit D6 of defendant's handbook provides that, quote, the company shall summarily dismiss an associate if it is satisfied that he or she has committed any of the following: A, engaging in conduct likely to bring the company into dispute. B, neglecting to perform his or her duties or performing carelessly and improperly. C, negligence, theft, fraud, or willful damage to the company's property. D, any proven compliance or integrity violation. In addition, the following will constitute gross misconduct and result in summary dismissal: refusal to undertake duties in accordance with the contract of employment. Flowing from the foregoing, the defendant's counsel concluded that claimant's action or inactions in performing his supervisory roles fall under any or all of the above infractions, namely the dereliction of duty, negligence, refusal to undertake contractual duty, and engaging in conduct likely to bring the company into disrepute, which are all valid grounds for summary dismissal. I must say that the defendant did not state the particular section or paragraph of the provisions above in the defendant's handbook. Earlier in the statement of defense in paragraph 2.6.4, the defendant averred that the claimant confirmed that there were mistakes and typographic errors in the data collected and submitted by the auditors in Yola and Kano, that most data of purchases collected were in oral form due to shop owners' inability to maintain diaries, that most data of purchases collected were in oral form due to shop owners' inability to maintain diaries, that Andrew Michael cheated in outlet number 022266, Kano. To the defendant, this confirmation by the claimant proved his guilt. I must pause here and state that it seems that honesty has no place in the dictionary of the defendant. This is so because from all the highlighted above, the claimant was just stating the obvious, which by the time he wrote the reply to the query, these things are things the defendant might have been aware of, considering the fact that it had earlier interrogated Auditor Andrew Michael and Auditor Emmanuel Anyoga, whom, according to the defendant, indicted the claimant. The claimant was just giving an honest and factual reply to the query, and I do not see how such honesty became twisted in the evaluation of the defendant. The question is, if the claimant said all this, it is also the indictment on their own part as a company. For example, the claimant said there were mistakes and typographic errors in the data collected and submitted by the auditors in Yola and Kano. What tools and apparatus was the defendant planning to put in place to forestall such future errors from auditors? Or was the claimant also one of the auditors? As rightly stated in paragraph 9 of the claimant's reply to the defendant's statement of defense, the defendant gave him a mandate to check all the data by spot check of 15% to 20%. If this in the case, how can the defendant find the claimant wanting when his mandate was to vet between 15% and 20% of the data, as if any error in the remaining 80% is his fault? Also, when the defendant said that most data of purchases collected were in oral form due to the shop owner's inability to maintain diaries, what did the defendant do to remedy this other than dismissing the claimant? When the claimant said that Andrew Michael cheated in outlet number 22266, Kano, was the claimant Andrew Michael who cheated, or was Andrew Michael an employee or agent of the claimant? The only part that affected the claimant directly was the part he stated that the submission of the work plan not having visit time was an oversight on his part. If this error is treated as fundamental one by the defendant, I don't see why they want this court to see their own error in the letter of dismissal taking retroactive effect as a minor error. Else, if they can see that nobody can be above mistake or error, then the oversight of the claimant not having visit time on his work plan should be something that ought to be treated as a minor error, and same should be given back to the claimant to impute the proper time. This kind of negligence should not be one that should be equated with gross misconduct capable of attracting the ultimate punishment of dismissal. The claimant also stated that the outlet classification was done on auditor's phone, which the claimant did not have access to. What did the defendant do to remedy this? Whilst the court recognizes the power of the employer to hire and fire anytime, the abuse of this power has become so glaring in the labor and employment industry, thereby prompting the court to put a restraint on this power. In this vein, the track law now is that the employer has a duty to ensure that it does not enigmatically raise its executive stick in operation of the employee, whilst exercising its power to fire. More so, such power should be exercised with equity, fair play, and equal treatment, because these are the factors and elements that constitute justice. See the cases of Adewumi versus Nigeria Eagle Flour Mills, reported in 2014, 14 Nigeria Weekly Law Report, part 1428, page 443 at 459. Then paragraph D. See also UBN PLC versus Chinyere, reported in 2010, 10 Nigeria Weekly Law Report, part 1428, page 443. From the facts and circumstances of this case, It is obvious that the big stick that the defendant wielded in dismissing the claimant was bigger than the offense. It is like killing a fly with the bullet of a gun. This is so because it is glaring that the claimant did not do any wrong directly against the defendant. At best, what can be ascribed to him is negligence. Even the letter of dismissal made no pretense about it, that the offense of the claimant was negligence. For the avoidance of doubt, paragraph 2 of the dismissal letter, tendered as Exhibit C9, is here reproduced. Quote, following the suspension, further investigation was conducted within your span of control, and it was discovered that your negligence with auditors 093, 094, 355, and 263 allowed data falsification, and your actions violated our standard operation procedures, code of conduct as stated by the company policies, and code of conduct with regards to this case of fictitious data within your control span, which you are responsible for. From the foregoing, melting the ultimate punishment of dismissal for gross conduct is like visiting the sins of the auditors who were shortchanging the defendant on the claimant. Even the Almighty God stopped visiting the sins of the fathers upon the children since the time of Ezekiel in the book of Ezekiel 18. I therefore wonder why the defendant cannot take a cue from there and resist the temptation of visiting the sins of erring auditors on that of the claimant, whom, for all intents and purposes, may not have seen the tactics of the auditors, as some may have been carefully hidden from him. I also make bold to say that sometimes it is not enough to give somebody a role without the necessary supporting tools. I say this because the defendant in the statement of defense stated the onerous task of the claimant as a supervisor, which included tracking and documenting each auditor's field performance through performance reports that will be submitted to the DA manager. The defendant only stated the task. It did not state the logistics put in place to enable the claimant efficiently track and document auditors under him as a supervisor supervising Yola and Kano branches of the defendants. How can you throw a person in a canoe with a paddle, yet you expect him to be as efficient and fast as a person in a speedboat? In claimant's final written address, the claimant pointed the court to page 48 of the defendant's handbook, where it is provided thus: final warning. A final written warning letter will be issued for serious offenses. Examples, which are not exhaustive, of offenses they may apply include being under the influence of alcohol during working hours, actions or behaviors which, etc., breach of security and compliance, bringing the company into disrepute, etc., insubordination, negligence leading to loss, damage, or injury, password violation, publicly outrageous behavior, unauthorized absence, verbal or physical abuse of a minor nature, etc., etc. It is glaring from the provisions above that in a matter of negligence, what is required is warning up to the last warning. In the case of claimant, there is evidence before me that he received, there is no evidence before me that he received any warning before his summary dismissal. which the court had earlier held that it was too heavy a punishment to be meted out to the claimant. Furthermore, there is no evidence before me that prior to the act leading to the dismissal of the claimant was found wanting in his duty as a supervisor. In this vein, this court finds and holds that the defendant was wrong to have meted out the ultimate punishment of dismissal to the claimant. What the defendant would have done, given the circumstances, was to have warned the claimant in accordance with page 48 of his handbook, because the negligence was not as fundamental as to warrant dismissal in accordance with page 49 of the defendant's handbook. Whenever the court finds that determination of or dismissal of employment was wrong, the next line of action is what will be the measure of damages. See the case of Gege versus Nande, quoted in 2006, 10 Nigeria Weekly Law Report, part 988, page 256 at 266. Also, the case of Ekawo versus Nigerian Army, quoted in 2010, 16 Nigeria Weekly Law Reports, part 1220, page 419 at 421 to 422, where it was held, and I quote, in an action for wrongful termination or dismissal or retirement, only two primary issues call for determination. And these are: one, whether the termination, dismissal, or retirement of the plaintiff is wrongful. Two, what is the measure of the damages recoverable where the termination, dismissal, or retirement is found to be wrongful. Now, having determined that the dismissal of the claimant was wrongful, what is left for the court to determine is the measure of damages available to the claimant. In the case of NEPA versus Adeyemi, reported in 2007, 3 Nigeria Weekly Law Report, part 1021, page 315 at 336, the court held, and I quote, the damages payable for any employment that has been wrongfully terminated are not at large. An employee whose employment has been wrongfully terminated is only entitled to what he would have earned over the period of notice. In the case of NEPA versus Adeyemi Supra, the court found the termination of the employment wrongful for failure to give notice. Hence, the damages was limited to what the employee would have earned over the period of notice. Whenever the court finds the termination of an employment to be wrongful, other than for failure to give notice, cases limiting the damages to what the employee could have earned for the period of notice becomes distinguishable. In the case of Esowe versus Golden Guinea Breweries Limited, quoted in 2000, 8 Nigeria Weekly Law Report, parts 670 at 658, paragraphs D to F. The court made it clear that the dismissal of an employee is not necessarily illegal or unconstitutional because it is contrary to the terms of the document governing the relationship between him and his employer. If the document is only the product of mutual agreement between the parties, not imposed by statutory law, then non-compliance will not necessarily result in an illegal act. It may result in a wrongful act, for which the employer may in law be held liable in damages to the employee. The court, having held that the dismissal of the claimant was wrongful, also noticed that if the period the claimant worked with the defendant is taken into consideration, the claimant worked with the defendant for 17 years, spanning the period of 2001 to 2018, when he was wrongfully dismissed. This means that the claimant put in 17 years of his life into the employment of the defendant. Yet for a minor offense of negligence, I call it minor because from the facts and circumstances of this case and the evidence adduced, the offense linked to the claimant was not fundamental except the one linked to the auditors, which in any event was theirs to be punished for. The defendant threw all the 17 years of the claimant away from the annals of history by summarily dismissing him. It is opposite for me to state here and now that sometimes employers should put a human face to the things they do to employees. An employer may be so used to seeing the face of an employee to the point that he no longer wishes to see him, but does not mean that such employee whom hitherto had no blemish should now be treated like a tissue paper, used to wipe the bottom, thrown into the toilet and violently flushed away. From the facts and evidence before me, the claimant's work with the defendant, attracted award given to him. There is no evidence before me that the claimant had been found wanting in his job prior to the incident that led to his dismissal in 2018. The defendant did not show anything in their testimony or evidence that the claimant had prior record of any offense. Therefore, the defendant should not have treated the claimant like a puppet always gone astray. This is so because the present offense to which the claimant was summarily dismissed has majorly nothing to do with the claimant but the auditors of the defendant. It is therefore safer to say that the punishment of the claimant, if severe, should have been final, as provided for under negligence in page 48 of the defendant's handbook, and not dismissal as provided for under negligence in page 49 of the defendant's handbook, and I so hold. The attitude of the defendant in wielding the biggest stick in the house against the claimant for a first-time offense, which is a non-fundamental negligence, may have given the defendant away that it had already premeditated the punishment for the claimant, and it was immaterial whether the offense was of a grave nature or not. It may as well be that it was the premeditation that unconsciously played on the defendant to put the effective date of dismissal to a backward date of 23 July 2018. In any event, the claimant's claim for the wrongful dismissal is the sum of 2,463,756 naira, representing his 1 year's gross salary as damages. This court wishes to state that from the facts that the claimant worked for the defendant for good 17 years before his wrongful dismissal, this amount claimed is a modest one from the claimant. Since the claimant is modest not to want more than this, the court will therefore limit itself to granting the same as damages against the defendant for wrongful dismissal of the claimant. In this regard, relief number 2 of the claimant succeeds. As to relief number 3, which is on costs, the court wishes to state that the general rule which this court has taken judicial notice of is that a successful party who conducted and comported himself well during trial before the court is entitled to costs. See the Supreme Court's decision in Mekunye versus Emirates Airlines, reported in 2019, LPELR 46553, Supreme Court, where it was held, and I quote, "The point has to be made that a successful party to litigation is entitled to be awarded costs, except where he or she misconducts his or herself," unquote. In this vein, this court, having found no misconduct on the part of the claimant in the trial of this suit, hereby awards him the sum of 1,000 naira in his favor, which is an overflow from the sources of his case before this honorable court. That's the judgment of the amount awarded is 1 million naira in his favor, which is an overflow of the sources of his case before this honorable court, including, of course, the amount he chose to be given. That is 2,463,756 naira. This is the judgment of the court, and it is entered accordingly.
Yes, continue.
My Lord, we are grateful for the word considered judgment of the court.
Oh.
The claimant has suffered enormous damage.
I see.
And my Lord, from the inception of this case, the claimant had to travel all the way from Yola to Lagos at every point in time.
I see.
And my Lord, from the record of the court also, we show that the dismissal of the claimant has restricted him from getting any employment. And to this effect, my Lord, we'll be asking for additional cost in favor of the claimant.
Counsel, listen to that. Is it who does that? This is the judgment of the court. Yes. This is the judgment. I don't even have the right to go back and touch any word I've already delivered now. Yes.
My Lord, we thank your Lordship for the industry in delivering this judgment, even during vacation, considering the age of this matter. We are grateful that it has finally come to an end. Very grateful.
Thank you very much. Okay. That leaves us with only one judgment. Okay. That is which one? Do you have your 27?
Yeah.
Okay. Please call the next judgment. Hey, this one is long. I will call the next one.
Case number NICN/LA/27/2024 between Andrew Chizoba Malangu and First City Monument Bank PLC. My Lord, parties are absent.
Okay. Appearances.
May it please your Lordship?
Yes.
I am calling Obonna.
Okay.
I humbly appeal.
Okay.
I'm most grateful, my Lord.
Yes.
With the most
yes.
The Lordship BJ Jacob.
BJ.
BJ.
Yes.
Babajide.
Yes.
Lordship, my humble appearance.
BJ Babajide who?
Oyedele.
Oyedele, okay. Your voice was breaking. Yes.
OYE.
Okay.
LE.
Yes.
Very grateful.
Yeah, for the defendant.
Yes, your Lordship.
Okay. Okay. So please listen to the judgments. This suit this suit was instituted by the claimant applicant via an originating summons dated and filed the 8th of February 2024, submitting the following questions for determination. A, whether, having regard to the failure of the defendant to serve the claimant with a written letter of suspension or termination of employment, or letter informing her of the decision of his disciplinary panel in her case, pursuant to the provisions of paragraph 1.9 of the defendant's staff handbook, the claimant's employment with the defendant still subsists. And whatever disciplinary measure the defendant allegedly took against the claimant, including but not limited to the stoppage of her salaries and emoluments with effect from December 2012, is wrongful for breach of paragraph 1.9 of the defendant's staff handbook. B, whether, having regard to the allegations of crimes constituted in charge number FHC/L/241C/2013, Federal Republic of Nigeria versus Andrea Chizoba Okpalangu, and appeal number CA/L/CR/465/2020, Andrea Chizoba Okpalangu versus Federal Republic of Nigeria, and the failure of the defendant to issue and or serve the claimant with a written letter of suspension or termination of employment, or letter informing her of the decision of its disciplinary panel in her case, pursuant to the provisions of paragraph 1.9 of the defendant's staff handbook, the defendant was wrong in law to have stopped paying the claimant's salaries and other emoluments with effect from December 2012 before the conclusion of charge number FHC/L/241C/2013, Federal Republic of Nigeria versus Andrea Chizoba Okpalangu, and appeal number CA/L/CR/465/2020, Andrea Chizoba Okpalangu versus Federal Republic of Nigeria. C, whether, having regards to the judgment of the Court of Appeal in appeal number CA/L/456C/2020, Andrea Chizoba Okpalangu versus the Federal Republic of Nigeria, wherein the claimant was discharged and acquitted of all allegations of wrongdoings and crimes leveled against her by the defendant, and the failure of the defendant to issue and or serve the claimant with a written address of a suspension or termination of employment, or letter informing her of the decision of his disciplinary panel in her case, pursuant to the provisions of paragraph 1.9 of the defendant's staff handbook, the claimant ought to be restored to her position as Assistant Officer 1 or any other higher position which would have been had the defendant not falsely accused her of fraud and be paid all her salaries and entitlements with interest thereon as an Assistant Officer 1 from December 2012, when the defendant stopped paying her salaries and emoluments till the date of her restoration. D, whether, having regard to the reputational damage, disgrace, humiliation, psychological/mental and emotional torture, physical sufferings, economic losses, blacklisting by banks, and inability to work in any financial sector in Nigeria and anywhere in the world, wrongful determination for 8 days at the Nigeria Police Special Fraud Unit, Milvat and Ikoyi, Lagos, wrongful incarceration for 10 months and 26 days at the Kirikiri prisons, Lagos State, and loss of marriage opportunities, all of which the claimant suffered as a result of the defendant's false accusation. The claimant is entitled to the award of maximum general damages possible against the defendant. And E, whether, having regard to the facts in questions A, B, C, and D, the defendant ought to tender a public apology to the claimant, published in 2 national newspapers circulating in Nigeria. Flowing from the above, the claimant applicant seeks the following reliefs. A, 1, a declaration that, having regard to the failure of the defendant to serve the claimant with a written letter of suspension or termination of employment, or letter informing her of the decision of his disciplinary panel in her case, pursuant to the provisions of paragraph 1.9 of the defendant's handbook, the claimant's employment with the defendant still subsists, and whatever disciplinary measure the defendant allegedly took against the claimant, including but not limited to the stoppage of her salaries and emoluments with effect from December 2012, is wrongful for breach of paragraph 1.9 of the defendant's staff handbook. 2, a declaration that, having regard to the allegation, of crimes constituted in charge number FH/L/2416/2013, Federal Republic of Nigeria versus Andrea Chizoba Okpalangu, and appeal number CS/L/CR/465/2020, Andrea Chizoba Okpalangu versus Federal Republic of Nigeria, and the failure of the defendant to serve the claimant with a written letter of suspension or termination of employment, or letter informing her of the decision of his disciplinary panel in her case, pursuant to the provisions of paragraph 1.9 of the defendant's staff handbook. The defendant was wrong in law to have stopped the payment of the claimant's salaries and other emoluments with effect from December 2012, before the conclusion of the charge number FHC L241C/2013, Federal Republic of Nigeria versus Andrea Chizoba Okpalangu, and then appeal number CA/L/CR/465/2020, Andrea Chizoba Okpalangu versus Federal Republic of Nigeria. The third one is a declaration that, having regard to the judgment of the Court of Appeal in appeal number CAL/L/465/C/2020, Andrea Chizoba Okpalangu versus Federal Republic of Nigeria, where the claimant was discharged and acquitted of all allegations of wrongdoings and crimes leveled against her by the defendant, and the failure of the defendant to serve the claimant with a written address of suspension or termination of employment, or letter informing her of the decision of his disciplinary panel in her case, pursuant to the provisions of paragraph 1.9 of the defendant's staff handbook. The claimant ought to be restored to her position as Assistant Officer 1 or any other higher position in the defendant, which she would have been had the defendant not falsely accused her of fraud, and be paid all her salaries and emoluments with interest thereon as Assistant Officer 1 from December 2012, when the defendant stopped paying her salaries and emoluments, till the date of her restoration. The fourth is an order directing the defendant to forthwith restore the claimant to her position as Assistant Officer 1 or any other higher position in the defendant, which she would have been had the defendant not falsely accused her. 5, an order directing the defendant to forthwith paid the claimant her salaries at the annual rate of 2,951,333 naira 33 kobo, or 245,944 naira monthly from December 2012 till the date of her restoration or the date of judgment in this suit, whichever is applicable. 6, pre-judgment interest on the sum awarded in Relief 5 above, and at the rate of 4% per annum from December 2012, when the defendant wrongfully terminated the claimant's employment and stopped paying her salaries, till the date of her restoration or the date of judgment in this suit, whichever is applicable. 7, post-judgment interest and on the sum arrived at in Relief number 5 and 6 above, at the rate of 10% per annum from the date of judgment until final liquidation. 8, general damages in the sum of 1 billion naira, being compensation for damages suffered by the claimant as listed in question D above. 9, an order directing the defendant to tender a written apology to the claimant and publish them in 2 national newspapers, that is, any 2 of the following: Guardian newspaper, This Day newspaper, Punch newspaper, or Vanguard newspaper circulating in Nigeria. And the 3rd is cost of prosecuting this suit. In support of the originating summons is a 39-paragraph affidavit deposed by the claimant applicant and attached thereto are 4 exhibits, which the claimant places reliance on. The claimant applicant also filed a written address in compliance with the rules of this honorable court. The gist of the affidavit in support of the originating summons is that the claimant was employed by the defendant on the 14th day of February 2007 as an assistant officer 2. Her employment was later confirmed on the 31st day of August 2007. During her employment with the defendants, she worked in various departments and units within the defendants. In 2012, she worked in the business banking unit, that is marketing. And her principal duty was to market the defendant's products to potential customers with the aim of getting customers for the defendants. Sometime in November 2012, the defendant accused her of fraud as conniving with 2 companies or clients of the defendant whom she marketed and brought in as clients for the defendant in the course of her job with the defendants. The accusation was that she defrauded the defendants to the tune of 146,633,000 naira, which in reality, the sum was money advanced as loans by the defendants to the staff of the companies named above under the defendant's salary plus loan package. Sequel to the accusation, the defendant issued 2 queries in writing to the claimant, to which she responded and submitted to the defendant, but she was neither given copies of the queries nor her answers. Based on the written queries and answers, she was later invited by the defendant to face the defendant's disciplinary panel sometime between 27th November 2012 and 4th of December 2012, where she answered all questions put to her and was asked to leave. That the defendant never communicated or advised her on the outcome and or the decision of his disciplinary panel, whether she had been suspended, her employment had been terminated or even dismissed in writing or orally. No communication of any kind was given to her by the defendant in contravention of paragraph 1.9 of the defendant's staff handbook. After the end of the disciplinary hearing on the 4th of December 2012, when the claimant resumed work on the 5th of December 2012, and on attempting to log into her work computer, she discovered that she had been logged out of her work computer by the defendant and her work email deactivated. Before long, she was bundled into one of the official cars of the defendant and taken to the Police Special Fraud Unit, Milverton Road, Ikoyi, Lagos. In his written address, the claimant applicant raised 5 questions for determination. The first one is whether, having regard to the failure of the defendant to issue and or serve the claimant with a written letter of suspension or termination of employment, or letter informing her of the decision of its disciplinary panel in her case, pursuant to the provisions of paragraph 1.9 of the defendant's staff handbook, the claimant's employment with the defendant still subsists, and whatever disciplinary measures the defendant allegedly took against the claimant, including but not limited to the stoppage of her salaries and emoluments with effect from December 2012, is wrongful for breach of paragraph 1.9 of the defendant's staff handbook. B, whether, having regard to the allegations of crime constituted in charge number FHC/L/241C/2013, FRN versus Andrea Chizoba Okpalango, and the appeal number CS/L/CR/465/2020, Andrea Chizoba Okpalango versus Federal Republic of Nigeria, and the failure of the defendant to issue and or serve the claimant with a written letter of suspension or termination of employment, or letter informing her of the decisions of his disciplinary panel in her case, pursuant to the provisions of paragraph 1.9 of the defendant's staff handbook. The defendant was wrong in law to have stopped paying the claimant's salary and other emoluments with effect from December 2012, before the conclusion of charge number, that is charged in the Federal High Court. We've been mentioning it all the time, FHC/L/241C/2013, and also the appeal by Andrea, that is CS/L/CR/465/2020, Andrea Chizoba Okpalango versus Federal Republic of Nigeria. The C is also whether, having regard to the judgment of the Court of Appeal in the above mentioned case, wherein the claimant was discharged and acquitted of all the allegations of wrongdoing and crimes leveled against her by the defendant, and the failure of the defendant to issue and also serve the claimant with a written letter of suspension or termination of employment, or letter informing her of the decision of his disciplinary panel in her case, pursuant to the provisions of paragraph 1.9 of the defendant's staff handbook. The claimant ought to be restored to her position as Assistant Officer 1 or any other higher position in the defendant, which she would have been had the defendant not falsely accused her of fraud, and be paid all her salaries and entitlements with interest thereon as an Assistant Officer 1 from December 2012, when the defendant stopped paying her salaries and emoluments till the date of her restoration. And lastly, whether having regard to the reputational damage, disgrace, humiliation, psychological/mental and emotional torture physical suffering, economic losses, blacklisting by banks, and inability to work in any financial sector in Nigeria and anywhere in the world. Wrongful detention for 8 days at the Nigerian Police Special Fraud Unit, MINVAT in Ikoyi, Lagos. Then wrongful incarceration for 10 months and 26 days at the Kirikiri Prison, Lagos State, and loss of marriage opportunities, all of which the claimant suffered as a result of the defendant's false accusation. The claimant is entitled to the award of the maximum general damages possible against the defendant. E is whether having regard to the facts of the questions A, B, C, and D, the defendant ought to tender a public apology to the claimant, published in 2 national newspapers circulating in Nigeria. Arguing question 1, the learned applicants counsel. Counsels, I'm so sorry, I'm going to skip the submissions of the learned counsel to the applicants counsel. Because yes, counsel virtually went to town on his submissions. It was quite exhaustive, and he cited authorities to support his submissions and so on. So I'm going to skip it. So now, on receipt of the process of the claimants, the defendant responded through one Mr. Abayomi Adeyeye, who identified himself as the admin assistant, supportive HR of the defendant, deposed to a 57-paragraph counter affidavit in opposition to the originating summons of the claimant applicant with a written address. The gist of his counter affidavit is that it was not responsible for the ordeal or emotional stress that the claimant went through. A fraud was committed against it by the claimant. It did its investigation, reported to the police, and at the conclusion of police investigation, she was charged to court. They were not parties to the cases at the Federal High Court or the Court of Appeal. In the defendant's written address, in opposition to the originating summons of the claimant, learned counsel on behalf of the defendant formulated 2 issues for determination. And these 2 issues are: A, whether or not the claimant's employment with the defendant subsists as to justify her claim for salary arrears and or restoration to her previous post without loss of promotion. B, whether the claimant is entitled to damages and a public apology from the defendants. The learned defense counsel submitted. In fact, he also made a copious submission to buttress his case. The court is also going to skip it for obvious reasons. Otherwise, we'll be here till 6 p.m. Okay. So the court is going to skip it. Okay, we go to. try and evaluate these submissions. On the claimant's submission that the defendant did not wait for the conclusion of the criminal matters before the defendant stopped paying the claimant's salary, defense counsel stated that the cases of Olarinwaju versus Afribank and MPA Ajobi relied upon by the claimant is distinguishable from the present case, as in none of the cases did the court hold that it was wrong for an employer to stop the payment of an employee's salary for failure to come to work. That the reason the defendant stopped paying the claimant's salary was due to her abandonment of work and not because she was facing criminal charges. Counsel urged the court to resolve this in favor of the defendant and to hold that having failed to report for work for 12 years, the claimant constructively terminated her own employment. On issue number 2, the defense counsel submitted that the alleged damages suffered by the claimant were not proved by the claimant, that the alleged damages, having crystallized prior to the commencement of the suit, are items of special damages, which must not only be specifically pleaded, but must be strictly proved. He relied on the case of ACB Limited versus NECA, BBB, MFG Company Limited, reported in 1996, Nigerian Weekly Law Report, Part 444, page 564 at 583, paragraph E to H, that the claimant did not adduce any independent evidence on the reputational damage, psychological and mental and emotional torture, and physical sufferings, even the blacklisting under Section 442D of the Banks and Other Financial Institutions Act. And the economic losses have also not been substantiated with the necessary evidence. That even the claims of the wrongful detention and incarceration are also unfounded, as the defendant was not responsible for the claimant's alleged detention and incarceration. He relied on the case of Faje Mirokun versus CB Nigeria, CBN Limited, reported in 2009, 5 Nigeria Weekly Law Report, Part 1135, Supreme Court, page 588 at 600, paragraphs B to C. Then page 606, paragraph A to E. Lastly, on claimant's claim for prejudgment interest of 4% interest per annum from December 2012 till date of judgment and thereafter at 10% per annum from the date of judgment until final liquidation of the judgment sum, Learned Defense Counsel states that interest is an item of special damages, which must be specially proved, pleaded and strictly proved, relying on the case of Diamond Bank Limited versus Partnership Investment Company Limited and another, reported in 2009, LPELR 939, Supreme Court. In the same vein, to be successful in a claim of prejudgment interest, a party must establish by means of credible evidence that exists an agreement, mercantile usage, or statute enabling or entitling him to claim prejudgment interest. He relied on the case of Pedgas Rest Limited versus Mbanefo, reported in 2007, 6 Nigeria Weekly Law Report, Part 1031, page 545 at 559, paragraphs E to F. Counsel urged the court to resolve this issue in favor of the defendants. Court, this is the resolution. Having gone through the processes of the claimants, that of the defendants, and written submissions for and against the originating summons, the court has distilled the sole issue for determination, and that is to say, whether the claimant has proved his case to be entitled to the relief sought. Before addressing the issue distilled above, this court wishes to state that the argument of counsel to the defendant that the nature of the declarative relief sought by the claimant are not such that could come by way of originating summons, but by way of pleadings that require the calling of evidence, have been taken care of by the ruling delivered by this honorable court on the preliminary objection earlier filed by the defendants. That said, the court will proceed to address the issue distilled above. In the questions posed by the claimant for determination, questions A, B, C, and D are intertwined, so I will take them and answer them together. The fulcrum of these questions is that the stoppage of salaries of the claimant, the non-service of suspension or termination notice on the claimant, the non-communication of the decision of the disciplinary panel's decision to the claimant, contrary to paragraphs 1.9 of the defendant's handbook, and the criminal prosecution of the claimant, which made her suffer emotional damage and torture. As for question number E, it is dependent on the answers to questions A to D. Also, being that the reliefs sought by the claimant are intrinsically tied to the determination of the questions posed by the claimant, the court will resolve same for or against the claimant in the body of his judgment. With regard to the questions posed by the claimant, this court would like to say that these questions cannot be properly determined without looking at and determining the nature of the employment of the claimant. The two major types of employment are employment with statutory flavor and the master servant employment. Under employment with statutory flavor, if the court finds the termination of the employment to be wrongful, it can order reinstatement. See the case of Olufeagba versus Abdul Rahim, reported in 2009, 18 Nigeria Weekly Law Report, Part 1173, page 384 at 397, where the court held, and I quote, in an employment with statutory flavor, the reason for the termination of the employment is very crucial to a case of both parties. The reason must be ascertainable and must be in accordance with the letter of appointment, governing regulations and statutory provisions. On the other hand, under a master servant employment, if the court finds the termination of the employment wrongful, it cannot order reinstatement, but it can order damages to be paid for wrongful termination. See the case of Samuel Ishenu versus Julius Berger, Nigeria PLC, reported in 2008, LPELR 1544, Supreme Court, where it was held thus. Where the employer fires an employee in compliance with the terms and conditions of their contract of employment, there is nothing the court can do as such termination is valid in the eyes of the law. It is only where the employer, in termination or dispensing with the services of an employee, does so without due regard to the terms and conditions of the contract of employment between the parties, that problems arise. As such, a termination is usually not tolerated by the courts and are, without hesitation, usually declared wrongful and appropriate measures of damages awarded to the plaintiff. The above position is born out of the principle that you cannot force a willing employee on an unwilling employer, whereas those in the public sectors enjoy employment with statutory flavor because the employment is bound by statutory Those who work in the private sector enjoy master servants employment because the employment is bound by individual contracts entered into with their employers. Fortunately or unfortunately, the case of the claimant who worked with the defendant, a private sector bank, is that of master servants. As such, even if the court finds that the action of the defendant was strongly wrong, she cannot be reinstated, but can only be awarded damages in concomitance with the level of wrong committed against her. According to the claimant, the action of the defendant run contrary to paragraph 1.9 of the defendant's handbook. On the part of the defendant, they stated that they did not terminate the employment of the claimant, but she stopped coming to work after her arrest, prosecution, sentencing, and acquittal by the Court of Appeal. In paragraph 1.9 of the defendant's handbook, it is provided as follows: staff discipline / code of conduct. Compliance with the bank's rules and regulations and general discipline is necessary among staff to enable the smooth running of the bank. FCMB, therefore, expects a high level of discipline and sense of responsibility from all its employees. No disciplinary action should be taken against an employee without an investigation to establish the facts. During such an inquiry, A, the employee should always be given an opportunity to state his or her case. B, the employee should always be informed of the outcome and of any decision on disciplinary action. Such advice should be given in writing, with exception of cases where the warning is verbal. Unquote. From the above, the claimant argued that even though she was made to face a disciplinary panel over allegations of fraud, the outcome of the decision was not communicated to her, only for her to resume work on the 5th of December to discover that she has been logged out of her work computer and her work email deactivated. That same day, she was taken into the vehicle of the defendant and taken to the police, thereby ushering in the genesis of her criminal trials at the Federal High Court. The defendant, while not necessarily disputing the parts on a decision not served on the claimant, posited that the claimant absconded from work, thereby constructively terminated her own employment. First of all, by virtue of paragraph 1.9 of the defendant's staff handbook above, the defendant owed the claimant a legal duty to communicate her the outcome of the decision arising from the disciplinary panel proceeding. Therefore, failure to communicate is not only wrongful, but violates the rights of the claimant as encapsulated in paragraph 1.9 of the defendant's handbook, and I so hold. Secondly, the defendant made mention of constructive dismissal on part of the claimant. It is opposite for me to say here that sometimes it is worthy for men to have a heart of flesh and not a heart of stone. I say this in view of the fact that from the evidence before me, right from the arrest of the claimant, her detention prior to trial, her trial and sentencing at the Federal High Court, leading to her incarceration, was all engineered by the defendant. Even the so-called police whom the defendant is adamant were the ones who prosecuted the claimant, could not call any witnesses Rather, all the witnesses who testified against the claimant at the Federal High Court were all in the employment of the defendant. Yet the defendant wants this honorable court to believe such a person whom they subjected to such a horrible ordeal was someone they still wanted in their employment. They were the ones who constructively dismissed the claimants right from the moment they failed to dignify the humanity in the claimant by writing her the outcome of the decision of the panel. Rather than dignify with a response, they chose to undignify her humanity by handing her to the authority to complete their dirty jobs. I have read through the judgment of the Federal High Court and the judgment of the Court of Appeal, overruling the sentencing of the claimant by the Federal High Court and discharging and acquitting the claimant. I am not only in total agreement with the decisions of the Court of Appeal that the defendant made the scapegoat of the claimant, but I'm also of the view that the defendant succeeded in giving the claimant a bad name, and it was done. It thanked her. I'm quite shocked that the Federal High Court, which was the court of first instance in the criminal trial of the claimant, couldn't look beyond the prosecution to see the real prosecutor of the claimant was not the police for the defendant's hearing. From the facts and evidence before me, and from all I have read from the proceedings/records of the Federal High Court, the judgment of the Federal High Court and the judgment of the Court of Appeal, which were all attached to the process of the claimant's hearing, the defendant cannot deny that they were the ones that arrested the claimant and took her to the police. They cannot deny that they set the law in motion against the claimant. They cannot deny that they set off the instrumentality of the justice system against the claimant. They can come now and save their face by saying that they were not party to the suit, but just a Jacob feigned the hand of Esowe, but could not feign his voice. So also the defendant could not hide the fact that in all travels the claimant went through in the hand of the police and the prosecution of the charges against her, the voice behind all those travels had been indisputably that of the defendant. Mortal men must know that the eyes that cry can still see. The Court of Appeal could see through the voice and background activities orchestrated by the defendants in the travails and criminal trials of the claimant. Hence, the acquittal of the claimant on appeal. The court can also see through the voice and activities of the defendant in all the calamities that befell the claimant. Therefore, the defendant cannot exculpate itself from all the travails and emotional stress caused the claimant, and I so hold. Okay.
Last call, please.
It is obvious that the defendants did not want anything to do with the claimant again in his employment. But rather than act like gentlemen about it, they decided to play the rogue by involving the police and passing the buck of the rogueness to the police, so that rather than fingers pointing at them, the fingers will be pointing at the police. This court can see into the gimmicks of the defendants in all of this, because it is as clear as 12 o'clock in the noon. In this vein, this court finds from all the evidence before it that it was the defendant who constructively terminated the employment of the claimant, and I so hold. From the attitude of the defendants towards the claimant, it is clear now why in Bible times, particularly in Luke 11, verse 46, Jesus was so vexed with the burdens placed on the ordinary people to the point that he was moved to say that woe betide those who load people with burdens that are hard to bear. Yet they themselves will not even touch the bodies with one of their fingers. In the case herein, even if the defendant is a corporate body, it is run and managed by those who are flesh and blood. The actions of these people against the person of the claimant is so appalling that it can make an ordinary man chuckle and ask if these persons can even subject themselves to bearing 1% of the burdens and travails that they made the claimants go through. Away from the Bible times and coming to the application of the law, to the fact before me, in the first question posed for determination by the claimant is asking if her employment still subsists, being that till death, no letter of suspension or termination was issued to her. At the same time, claimant wants to know if the stoppage of her salary with effect from December 2012 is wrong and in breach of paragraph 1.9 of the defendant's handbook. First off, whenever the court is called upon to determine the issue of whether an employment which on the surface has come to an end still subsists, the first thing the court will look at is whether the employment is one with statutory flavor or one that is master-servant. As earlier pointed out, in a master-servant relationship, the remedy of reinstatement or subsistence of employment does not avail the employee. What avails the employee is damages. As for damages, as relating to the claimant's position that she's yet to marry as a result of the allegation of the defendant, which has driven suitors away from her, this court would want to say that such a matter is a matter of the heart and not a matter of the courts or law. Matters of the heart are matters even the courts cannot fathom. Its depth is deeper than any man can even think or imagine. Furthermore, the allegation against the claimant that led to her travels are that of financial fraud, not that of love or platonic fraud that would warrant any suitor attracted to the claimant to turn around and say she's a fraud platonically. Therefore, given the intricacy of the matters of the heart, all that the court can say is that the defendant cannot be held liable. It will suffice to say that if Peter came, left without loving the claimant, a Paul will certainly come one day, stay and love the claimant with or without the actions of the defendants. In this vein, and from all that have been said, this court is not moved to grant any damages against the defendant on this head, and I so hold. As for questions A to D posed by the claimant, the answer to those questions is that the actions of the defendant run contrary to paragraph 1.9 of the defendant's handbook, which makes the action wrongful. But the court, being that the employment of the claimant was that of a master servant, cannot order reinstatement or hold that the employment of the claimant still subsists. The best the court can do is award damages. Furthermore, from all the facts and circumstances of this case, it is glaring that the defendant has constructively terminated the employment of the claimant. In this vein, the damages that follow constructive dismissal will avail the claimant, and I so hold. From the circumstances of this case, this court assesses the damages for wrongful dismissal to be 5 million. The constructive dismissal for 5 million and damages for trauma and pains cost the defendant through the ordeal that the defendant made her pass through at 20 million naira. From all that has been said above, the case of the claimant succeeds as follows. Relief number 1 succeeds to the extent that action of the defendant in not informing the claimant of the outcome or decision of the disciplinary panel is wrongful, and it contradicts paragraphs 1.9 of the defendant's handbook. Relief number 2 succeeds also to the extent of relief number 1 above. Relief number 3 fails because, given the circumstances of this suit, the claimant cannot be restored to her position in the defendant's employment, nor can the defendant be made to pay her salaries from December 2012 till date. Relief number 4 succeeds only to the extent that the claimant cannot be restored to her position, but shall be paid the sum of 5 million naira for failure to serve the claimant's suspension notice or termination notice, or the outcome of the decision of the disciplinary panel, in line with paragraphs 1.9 of the defendant's handbook. Relief number 6 succeeds only to the extent that the claimant cannot be paid her salary from December 2012 till date, but shall be paid the sum of 5 million naira for constructive dismissal by the defendant. Relief number 6 fails for, given the circumstances of this suit, this court is not moved to grant any percentage as pre-judgment interest. Relief number 7 fails for, given the circumstances of this suit, this court is not moved to grant 10% per annum as pre-judgment interest. The court will rather give a time frame for the judgment sum to be offset. Failure thereafter shall attract a 5% interest rate. Relief number 8 succeeds only to the extent that the defendant shall pay the claimant the sum of 20 million naira only, assessed by the court as damages for the trauma and the pains caused the claimant through the ordeal of the defendant made her pass through. Relief number 9 succeeds. For given the circumstances of this case, the claimant desires an apology from the defendant to clear her name and image. This is the judgment of the court, and it is entered accordingly.
On behalf of the claimant, I want to sincerely for the industry and resolution of the issue. I would only use this opportunity to pay them.
Thank you.
The defendant's counsel, within the spirit of settlement and the spirit of advice its clients to kindly honor the judgment of the court has passed. I'm most grateful to you.
Yes.
The Lordship were very grateful for the well-considered judge, and we wish you rest. Thank you.
Thank you very much. The court shall rise.
Court.
Thank you.